What's up, y'all? Welcome to my channel. I'm excited today. I finally made it to 200 subscribers on my YouTube. That was actually my goal by the end of 2025. I wanted to make it to at least 200 subscribers. I made it, so now I have to set a bigger goal for 2026. If you are new here to me, welcome to my channel. I talk about everything credit and federal student loans related. I also love to read case law, so that's a lot of what you'll be seeing on this page. I like to kind of understand how processes and how procedures and things of that nature work when things are granted, especially dealing with the Department of Education, anything that brings harm to consumers and federal student loan borrowers, I love to get into it and also try to help those who are consumers and those who are student loan borrowers just be able to fight back and how to just, become more empowered. So that's what I like to do on this channel. So welcome to all of my new subscribers. If you are here, make sure you like and subscribe to my channel. I want to get it built up. I don't know what my goal is going to be for 2026. I'll figure that out later. But speaking of law, we're going to go over to Project on Predatory Student Lending. If you are someone and you are a applicant or you are a part of the Sweet versus Cardona settlement, there was some big news that came down on the 11th of December. The Department of Education, they filed a motion. They filed a motion on November 6th, and what they were trying to do or what they were requesting is that the courts allow them a 18-month extension on deciding applications that are part of the Sweet versus Cardona or Sweet versus McMahon settlement. They requested an extension. They wanted an additional 18 months. Now, mind you, they've had well over 3 years to make decisions on applications, which they have failed to do so. But their deadline was January 20th, 2026. If they did not make decisions, if they failed to make decisions on post-class applicants, that means those are those who put in their applications between the dates of June 23rd, 2022 and November 15th, 2022. If you fell between that range, the Department of Education had until the 28th of January to make a decision on your application, or you were entitled to full settlement relief. Well, the judge denied it. They denied that extension. Let's go back to PPSL so that way we can take a look at that and what actually took place. If you go to ppsl.org, as soon as you get here, you just click on Find the Latest Sweet Case Updates. And this is where you'll see all of the information connected to that ruling, okay? So it tells us, at the December 11th hearing, Judge Alsup ruled to deny the Department of Education's request to extend relief decisions for post-class applicants by 18 months. The following deadlines were granted. So all post-class applications related to Exhibit C school must be decided by the original deadline, which is the 28th of January, 2026. All other post-class application decisions must be decided by April 15, 2026. So we know that if your school was listed on Exhibit C, that means that the department has until the 28th of January to make a decision. If a decision is not made on your application, then you are entitled to full settlement relief. Any schools outside of that, so that means if your school is not on the list, that means that they have until April 15th, 2026 to make a decision on your application. Let's go take a look at those schools so that way it's clear which school that you attend and where you fall at in that range. All right, so let's go here and look. So when you get to the list of schools, you'll see on the left-hand side, you'll see the school owner, and then on the right, you'll see the school name. So you just want to take a look to see where you are. If your school is one of the ones, and I believe there's 150 or 151 schools that are on this list. So you just want to go through the list here and see where you fall. And some of you have attended multiple schools. So hopefully that your school that you put your application is on one of the ones that is on this list here. So you want to take a look at that, okay? And that way you'll see exactly where you fall, okay? But you can view that list. Just go back to ppsl.org, and that way you'll be able to see the information that's connected to the school list. All right, let's go back here. So once you go to ppsl.org, so from the beginning, right here at the top, find the latest on Sweet Case Updates. It's going to take you here, and this is where you'll see to find the full list of Exhibit C schools, click here. One thing that I enjoyed about if you were able to, first and foremost, when I tell you we came in hard, maxed out the Zoom, not only that, even YouTube, I believe YouTube was maxed out as well because everything was just acting crazy. But if you were able to attend that hearing, I tell you, it was just like, I don't know, it was just something to see. Like, I swear it was something to see. And I've posted some clips on my YouTube page and also other platforms as well, just so that you can just get that feeling. If you weren't able to be there, when I tell you what Rebecca Ellis, this is her right here. Like, listen, She did not come to play. She did not stumble over her words. She was very much well prepared. She knew this case in and out. Like I'm telling you, it was just something. Like I'm, my goal one day is to be in a courtroom, to be there present. And it was just something to see. Like you would have had to see it, like you just to be, and I wasn't there physically. I was over Zoom, and it was just, I don't know, it was just something to see how you would have to see it. But even prior to the actual hearing, I also like I said, I like to read case law. So one thing about me is that when PPSL, when they posted the information here, because they responded to the Department of Education's motion for this extension, and they responded like literally in less than 2 weeks. I was like, okay. So I wanted to read it. I like to go, like I said, I like to read case law. So I read through their response, but not only that, I wanted to look at the exhibits just to see the information as far as what the evidence was that they were coming into court with. And when I tell you, it was a lot. But one thing about this particular one here was the declaration of Rebecca Ellis, and she was the one who was in court. That I told you I was 100, I was like extremely impressed by her. Just reading the information here, I can tell she's extremely thorough, like extremely thorough. She is not to be played with. Like, so I read this information here, her declaration, and it was just like, just from this here, before I even saw her, in the courtroom, I knew like she was a beast. Okay. But it just says, I just said, I, Rebecca C. Ellis, state as follows. I'm submitting this declaration in relation to the above captioned case, who she is. And then the statements contained in here are true and accurate to the best of her knowledge. But it was just how thorough she was throughout all of this. And she's like, oh, I'm just going under number 9. I have personally reviewed the January 16, 2025 spreadsheet as updated with school information to determine the following statistics relating to post-class. And I wanted to know this information. So I just want to know where we stood as a post-class, how many members are in the post-class, even also what the schools, what their statuses was, just all of that information. And you get that here. So she says, I personally reviewed the January 16, 2025 spreadsheet that's updated with school information. Overall, there are 572,748 applications listed in the January 16, 2025 spreadsheet. One of the data fields in the spreadsheet labeled pending litigation. She just goes more into that, but we're going to scroll down a little bit. She talks about what software that she used in order to kind of simplify it in a sense. I guess that's the right word to use, but to narrow down where everything stood. Okay. But she said, I use Microsoft Excel to filter the post-class applications by schools for which the department has announced a group discharge. That is, the department has committed to discharging all loans from these schools within a certain time frame, regardless of whether borrowers submitted a borrower's defense application based on findings of widespread misconduct. And she tells you the group discharged in the name of the schools. If you are someone that attended one of these schools, the Department of Education, they have information directly on the student aid website where they break down why the loans were discharged as a group. Then also they provide you with that executive summary. So I'll show you guys that as well if you just were curious about it. But it's just more or less how she broke down the information, how she utilized it. There are 208,310 unique post-class applications. She tells you exactly what that means. Also, more or less about the survey. There was a survey that was sent out prior to the hearing so that they can get more information on post-class applicants, and how the Department of Education, if they were able or granted the request to those 18 months, how that would affect those who are post-class members. She tells how that survey was built. She's just really, really thorough. And I just really enjoy reading her entire declaration. So if you're just someone that want to go back and read it, I say go back and take a look at it. She tell you how many, what the percentage was of the responses, and what post-class applicants were saying, what that further delay would cause to them. But one of which that I read that really stuck out to me, one of the post-class applicants, and this was in Exhibit 2. This one really, really kind of hit me hard because I just lost my mother a little less than 6 months ago. Alice Ferris. And I actually have a clip of when Rebecca was in the courtroom and she was speaking to the judge, and she was speaking about the student loan, about a post-class applicant who was harmed. And this is the one, she was actually in the court. Miss Ferris was actually in court. And I don't know, my heart just like literally broke for her. But let me read this really quick, okay? And this is the declaration of her. It says, I, Alice Safara, state as follows. I am submitting this declaration in relation to the above captioned case. I am over the age of 18. The statements contained here are true and accurate to the best of my knowledge. Tells out where she lives, her age, that she borrowed federal student loans. The department accepted my borrower defense application early in the morning on June 23rd, 2022. I have been trying to submit my application for about 2 weeks. Before that, could not because of issues with the department's website. I understand that means I am currently considered a post-class applicant under the Sweet vs. McMahon settlement. On January 7, 2025, I notified the department that I tried to submit my application multiple times leading up to June 22nd, 2022 Sweet class inclusion deadline, and that as a result, I should be moved into class. However, the department has yet to let me know whether they will approve my request. So there were some post-class members in the Sweet settlement who were moved into class members due to having technical issues with the website when they were attempting to put in their borrower's defense application. There was a lot that was happening. It happened to me as well, but there were a lot of applicants who would have been a part of the class if they were not having technical issues, if the website was not having issues that prevented them from getting their application submitted in time. So this is what she's talking about in regards to that. She still hasn't heard back on her being, moved over into as a class member. But we get to, if the department is allowed to delay the post-class deadline by another 18 months, I will suffer harm as described below. When the Department of Education told me in writing that it would decide my borrower defense repayment application by January 28, 2026, I believed them. That date became something to hold on to, an endpoint. After years of uncertainty, I built my expectations and honestly, parts of my life around that promise. Delaying this decision by an additional 18 months, as the department has requested, is not simply a sporadic adjustment. It is a direct act that will continue to cause severe, escalating, and unnecessary harm to me and my family. She goes and tells about what her loans total. I borrowed for a degree for a school that no longer exists. My loans are in forbearance, but interest keeps accruing month after month while my application sits untouched. Each passing month without a decision turns a promise into a larger and more painful number. The settlement's deadline wasn't just administrative, it was a lifeline. Asking for an 18-month extension is asking the court to stretch that lifeline into a longer rope I'm forced to keep climbing. Since June 23rd, 2022, my application portal has shown the same stagnant status. Review for EU review, nothing has changed. I've become almost compulsive about checking for updates, refreshing the page far more than I'd like to admit. On the plus side, I've apparently developed an unexpected new skill in reading website back-end codes. Not exactly the professional growth I had in mind, but it's what's happened when you're desperate for any sign of progress. The financial impact is already real. My debt to income ratio is so distorted that I couldn't be added to the mortgage when my husband and I brought our home. It's a small thing on paper and missing signature, but it felt like an erasure, my role as a partner and provider sidelined by debt born from a degree I pursued to help others. We've also put off starting our family and delayed IVF because it would be financially reckless to take that step with unresolved debt. The emotional toll has been equally heavy. The ongoing uncertainty has led to panic, anxiety, and sleepless nights. I lie awake doing mental math, calculating interest, wondering how much longer this will drag on. It seeps into everything, my relationships, my work, even my ability to imagine a future without dread. To hear, wait a minute. I don't think I skipped a part. To hear the department's, okay, there it is. Okay, I thought I missed over something, but I didn't. So let's keep going. The emotional toll has been equally heavy. The ongoing uncertainty has led to panic, anxiety, and sleepless night. I lie awake doing mental math, calculating interest, wondering how much longer this will drag on. It steeps into everything, my relationships, my work, even my ability to imagine a future without dread. To hear the department describe borrowers like me as receiving a windfall is profoundly demoralizing. You have to read the motion that the Department of Education filed. The way they speak about student loan borrowers, about post-class applicants is absolutely insane. I mean, even in court, and I actually have a clip of that on my page as well, where the lawyer was speaking and the attorney for the Department of Education was speaking. And he's basically like, okay, well, yeah, I get that the harm is, it's sad, or well, not even that it's sad, it's unfortunate that there's, these loans are on their credit reports and so forth. But I mean, like there was just absolutely no care. I mean, even for this applicant here or this borrower here. But let me keep going. I'm gonna skip down to here because this is what my original thing was. Because this week brought the most painful consequence yet. My father passed away on Sunday night, and I'm unable to apply for a low interest funeral loan to pay for the services because of my debt to income ratio. That right here broke me down. Like I was just like, after just losing my mom, like I said, less than 6 months ago, to even have the thought that a student loan, especially from a school that was predatory, that you're not able to get the funds necessary to bury your parent. Oh, that really just completely just broke my heart for her. And I definitely want to send out my condolences to Mr. Ferris because in court, when the attorney, well, Rebecca Ellis, when she actually had her speak, or had the judge basically just wanted her to raise her hand, there was no, I did not see where the judge even offered condolences to her. I did not personally see it or hear it. So, it was just a lot to go through this, to see that she went through this, and not just, the student loans, but to know that she's dealing with the loss of her dad. And, she still made it to court, and she sat there, and yeah, so that was a lot for me. But you can continue to read more or less the other exhibits where you can see the declaration of other post-class applicants and just their stories. It's a lot. It's heartbreaking too. But um, I'm excited to see, what's to come and how the Department of Education actually, abides by this, how they're going to make these decisions on applications. Are they actually going to do, right this time? Are they actually going to really um, go through applications, or are they just going to be, attempt to do blanket denials, or, things of that nature? So we'll see what happens. We'll see what happens. But if you are someone, like I said in the beginning, on the student aid website, um, you can go back and read more or less about those group discharges if you attended one of those schools. And you can just simply get to that by going to loan forgiveness, borrowed offense to repayment, and then clicking on updates about borrowed offense. Okay, click on updates about borrowed offense. And this is where you're able to see all of the information for all of those schools. Okay, you just click on your school, and then this is where it'll scroll down as you're going, and you'll be able to see the executive summaries, all of that information. You can read all of that. Okay. But yeah, we'll continue to keep following everything. Stay connected to your student aid account. If anything changes with your student loans, make sure you're checking your email, because we know that the department likes to communicate through email. Also, make sure you're checking your regular mail as well. So that way, because we know if you are one of the ones your school is here, they have until the 28th of January to make a decision on your application. So, and if they don't, then that's where you qualify for your loans to be, well, your loans will be discharged. But if they send anything to you, regarding the application, you want to make sure that you get it, and that you're able to respond, quickly. So just, yeah, make sure you're checking this list out to see if you are one of the ones that's on the list. For those of you who are not on the list, you know that they have until the 15th of April to make a decision. If they don't, then, same things apply. I know that there's going to be another judge, because Judge Alsop is, ultimately sounds like retiring by the end of this month. So there may be, depending on what the Department of Education does, if they try to appeal or anything of that nature. But we'll see. I mean, I'm very 100%, more than 100% confident in this entire team. They are very much well prepared for whatever the Department of Education brings. And yeah, we'll just, stay connected, and then whatever's next. Like I said, we came in hard. That max, that Zoom out was shutting it down everywhere. So, and then to what the PPSL was doing in order to get post-class members to the actual physical settlement hearing. They were doing GoFundMe's, or I believe it was a GoFundMe where they were, yeah, GoFundMe that they were doing in order to get people there. So just a lot. So we'll stay connected, and we'll see what's next. But y'all, all right.